A judge speaks, and the entire future of the law shifts. Not because of what they feel, not because of what they prefer, but because of one Latin phrase that has silently governed every courtroom decision for centuries. Ratio Decidendi, the reason for the decision. And if you don't understand what it is, you don't understand how law actually works. Here's the shocking truth most people never learn. When a judge decides a case, not everything they say becomes law. Only one part does. The ratio. Everything else. It's legal noise. Persuasive, sometimes. Binding, never. But identifying which part is the ratio, that's where lawyers have fought, courts have disagreed, and entire legal systems have nearly collapsed. Let's break it down. The doctrine of stare decisis, the principle that courts must follow prior decisions, is the backbone of the common law system. But courts don't follow everything a previous judge said. They follow the ratio decidendi, the legal principle upon which the decision was actually based. Think of it this way. A judge could spend 40 pages discussing legal history, quoting Shakespeare, and speculating about justice. But only the narrow legal principle that determined the outcome of that specific case becomes binding precedent. That's the ratio. Now, how do you find the ratio? Scholars have been arguing about this for over a century, and two schools of thought dominate the debate. The first approach, look at what the judge said was the reason. The principle of law declared in the judgment to justify and explain the decision. If the judge articulates a legal rule, that rule is the ratio. Simple enough. Except judges don't always make it that clear. So a second, more controversial approach emerged, championed by legal scholar Goodhart. His argument? Don't trust what the judge says the reason is. Instead, extract the ratio from the facts the judge treated as material, combined with the decision based on those facts. In other words, watch what the judge does, not just what they say. Goodhart's position creates something remarkable. It means the ratio of a case is determined by the facts the deciding judge chose to treat as important and the decision given on the basis of those facts. Subsequent courts, according to this view, should have the freedom to ascertain what facts should have been regarded as material to the earlier case. Julius Stone, another towering legal mind, described this as the ratio of rations decidendi, the ratio of ratios. Because in practice, different courts looking at the same case can extract different ratios. The law, it turns out, is not as fixed as it appears. Now let's bring this into a real courtroom, because theory without facts is just philosophy. The year is 2003. Nigeria. A senatorial election for the Kwara South Senatorial District has just concluded. Chief Suleiman Makanjulo Ajadi of the All Nigeria People's Party is declared the winner. His rival, Chief Simeon Sule Ajibola of the People's Democratic Party, is furious. He files an election petition before the National Assembly and Legislative Houses Election Tribunal in Ilorin, alleging thuggery, rigging, manipulation of results, and violations of the Electoral Act 2002. He wants the result voided. He wants to be declared the winner. But before the petition even gets to trial, a preliminary objection is raised. The First Respondents Council argues the petition is fatally defective. Why? Because certain electoral officers whose conduct was being complained of were not joined as parties to the petition. Under Section 133 subsection 2 of the Electoral Act 2002, any presiding officer, returning officer, or electoral official whose conduct is being challenged shall be joined as a necessary party. The word shall means mandatory, not discretionary, not optional. Shall. The tribunal agreed partly. Instead of striking out the entire petition, it struck out only the offending paragraphs, those specific allegations relating to officials who had not been joined. Ajibola appealed, and then the tribunal proceeded to hear the remaining case and dismissed the petition entirely, holding that the election had been conducted substantially in accordance with the Electoral Act and that any non-compliance did not substantially affect the result. Ajibola appealed again, Both appeals were consolidated and heard together before the Court of Appeal, Ilorin Division, Ajibola and Ajadi, decided on the 27th of January, 2004. The Court of Appeal delivered a split ruling, unanimous in dismissing the appeal against the preliminary objection, but unanimous in allowing the appeal against the final judgment. The leading judgment, delivered by His Lordship Justice Ja'afar Mikulu, JCA, laid down several principles of lasting legal significance. First, on the question of necessary parties. The court held that non-joinder of officials whose conduct was being complained of is fatal to those specific allegations, but only to those paragraphs, not the entire petition. Where the surviving paragraphs can sustain the cause of action, the petition must go to full trial. Second, on the attitude of courts to election matters. The court reaffirmed that election petitions must be approached liberally. Courts must deal with substance over formality, and must not allow technicalities to defeat the course of justice. But here is where Ratio Decidendi becomes directly relevant to this very case. Justice Mikulu, in his leading judgment, was asked to consider certain cases cited by the appellant, Omaborio and A. Jason, 1984, and Igolum and Obasanjo, 1999. Counsel argued these cases supported their position. The court's response was surgical. Those statements from those cases were made obiter, they were not the ratio. They were judicial remarks made in passing, not necessary to the determination of those cases. They could persuade. They could not bind. And the court went further, defining both concepts for the record. Obiter dicta is an opinion of a court on a point not necessary for the decision of the case. It is persuasive, but not binding. Ratio decidendi is the enunciation of the reason or principle upon which a question before a court has been decided, the general grounds for the decision, detached and abstracted from the specific peculiarities of the particular case. This definition from Ajibola and Ajadi, 2004, aligns precisely with Salmon's classical conception of ratio decidendi, and it explains a profound legal truth. A case can be an authority for another case whose facts, though similar, are not the same. Because the ratio is abstracted from the specific facts, it becomes a general principle. It transcends the individual dispute. The case of Ofunne and Okoye, 1996, crystallized this into three propositions that remain instructive today. 1. The principle of law upon which a particular case is decided is the ratio decidendi, and it serves as the basis for the doctrine of judicial precedent. 2. Ratio decidendi is not merely a finding of fact, but a general legal principle enumerated in a case after its facts have been applied to that principle. 3. A statement made in passing by a judge which is not necessary to the determination of the case at hand is not ratio decidendi. It is obiter dictum, and for the purposes of judicial precedent, it has no binding effect. See also Adebayo and Johnson for further confirmation of this principle. So why does any of this matter to you, outside the walls of a law school? Because every time a court decides a case that affects your rights, your property, your liberty, the ratio of that decision ripples forward. It binds future courts. It shapes future outcomes. The judge who decided your great-great-grandfather's property dispute may have laid down a ratio that still governs land disputes today. The election case decided in Ilorin in 2004 set precedent on who must be joined in electoral petitions, precedent that Nigerian courts still consult. Every judgment carries within it a seed, a ratio, that can grow into law for generations. The question courts and lawyers must always answer is this: which part of what this judge said was truly necessary to the decision? Because that is what binds. That is what endures. Everything else is just words.